Today's courtroom drama has everything: a defendant who's already juggling multiple probations, shocking drug test results that leave the judge stunned, a desperate plea for one last chance, and finally, a decision that slams the door shut. Trust me, you're going to want to see how this one ends. And if you love real courtroom breakdowns like this, hit subscribe so you never miss the next twist.
Isaiah Paredes. And Mr. Paredes, best you can, please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. You can put your hand down. And so, Mr. Kimler, will your client waive the formal reading of the motion in each case?
He will.
Mr. Paredes, in cause number 16-24053, I have a motion to revoke your unadjudicated probation. This shows that you were placed on probation November 14th of 2016 for possession of a prohibited weapon, third-degree felony, and that was a 10-year deferred probation. Is that correct? Cause number 20-35329. I also have a motion to revoke your unadjudicated probation.
Did you catch that? He is not on just one probation, he's on 3. And she, the judge, is laying them out like a checklist of failure. It's like he built a legal Jenga tower, and she's about to pull the last block.
This shows that you were placed on probation March 7th of 2022 for aggravated assault causing serious bodily injury, a second-degree felony, and that was also a 10-year deferred probation. Is that correct? And then finally, in cause number 20-35328, I also have a motion to revoke your unadjudicated probation. Shows you were placed on probation March 7th of 2022 for aggravated assault causing serious bodily injury, a second-degree felony. That was also a 10-year deferred probation. Is that also correct? Each of these cases allege that you violated your probation. Count 1 in each case alleges that you failed to enter and successfully complete the JCDI program. Is that true or not true?
True.
Count 2 in each case alleges that you provided a urine sample June 12th, June 24th, July 10th, and July 31st that tested positive for tetrahydrocannabinol. And is that true or not true?
True.
THC or marijuana.
True.
Count 3 in each case alleges that you provided a urine sample July 31st of 2025 that tested positive for cocaine. And is that true or not true?
True.
Count 4 in each case alleges that you failed to provide verification of performing the community service hours as required. Is that true or not true?
True.
You sure?
Well, I did 1. I did 2.
And there it is, cocaine on top of repeated marijuana violations. He was given chance after chance, but she now has solid proof he broke the rules. Let me ask you, if you were in her position, would you give him one more shot, or shut the door for good?
Right before, the month before I turned myself in, so
2 hours?
I did 2 days. They said they were going to give me about 13 hours a day.
I think that's probably not true.
Yeah, it should have been about 25, 26 hours.
Okay. We'll do not true for that. Count 5 in each case alleges that you failed to submit to alcohol or drug screening as ordered June 18th, June 25th, July 2nd, July 5th, and July 21st as ordered. Is that true or not true?
Not true.
Okay. Count 6 in each case alleges that you're behind in your court-assessed fees. Is that true or not true?
True.
Did you enter your pleas of true in each case to counts 1, 2, 3, and 6 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
All right, then each of your cases, I'm going to find that you entered your pleas of true to counts 1, 2, 3, and 6 freely and voluntarily. Find those counts true. Find sufficient evidence in each case to find you guilty and revoke your probation. However, I'm going to reset your case so that the probation department can do an updated pre-sentence report. That'll give me more information about you, your probation, what's been going on. Also, at that hearing, if the state has any evidence with regard to those other counts, they'll be allowed to put that information on. Anything that you think is important for me to know, make sure you get that information to Mr. Kimler. He will present it to me on your behalf when we come back. These are unagreed. They're so let me make these notes and then. Brittany's mad. There's those. All right. So, Mr. Kimler also filed a request that I set bonds in these 3 cases. There are currently no bonds set. Is that correct? Mr. Kimler, you may proceed.
Your Honor, I appreciate the fact that these are serious cases, 2 ag assaults and serious bodily injuries, and a prohibited weapon, which I believe was a short barrel firearm. I don't know whether it was a rifle or a shotgun, which I guess at first glance would be indicative of someone's potentially danger to the community. I could only observe the evaluation by the state, the probation department, and I suppose the court of these cases initially was that they were more worthy of deferred adjudicated probation. The defendant's performance on probation has not been sufficient. He's fallen short. I would observe that there are no allegations of a new offense, but he has been remiss in taking care of his obligations. I don't know that he appreciates really the seriousness of what he's looking at in the event of a revocation. I can say that because he was somebody that's facing 20 years in penitentiary on an aggravated offense that can't refrain from the use of marijuana or THC, probably isn't taking their probation seriously, and doesn't fully comprehend the severity of what he's facing. I would ask the court to set bonds in these cases at an amount, hopefully, where he can meet those bonds in order to get out of jail and demonstrate to the court.
Notice the defense's play here. They admit he's failed, but still beg her for one more opportunity. Classic tactic, paint him as someone who just needs a little more time. But if you've been watching closely, you already know, she's not buying it.
During the time period the court is waiting on the updated pre-sentence report, that he can get back on track or get on track with his probation and hopefully perform a community service, do whatever evaluations that are necessary, and demonstrate to the court that he can refrain from the use of illicit substances. Really, it's kind of an opportunity for Mr. Paredes either to demonstrate to the court that he has the desire and ability to complete probation or not, and he comes back to the court in 30 days and hasn't done anything on probation, then obviously the court would take that into consideration to revoke him up to 20 years in penitentiary on an aggravated offense. So it's really would be up to him, and I'd like him to have that opportunity.
Well, let me just stop you because Mr. Paredes has had every opportunity. Mr. Paredes was on probation for that prohibited weapon case, placed on probation in 2016. Then we have 2 new aggravated assault causing bodily injury indictments while he's on felony probation, and for whatever reason got another opportunity on those 2 cases at a deferred probation, has been given every opportunity. There was an MTRP filed. He wasn't revoked before. He was given probation, a deferred probation, which probably I did deferred on those so that if he did continue to violate, that I would have the entire range of punishment. If I had to guess, that's probably what my thought process was. Given an opportunity at JCDI where he was unsuccessfully discharged, where they're trying to help him with all of these things, I think based on all of that, the underlying offenses, the nature of the aggravated offenses, the fact that the first one had to do with a prohibited weapon, I do not think it is in the best interest of our community while he's out using cocaine, marijuana, getting kicked out of JCDI and on probation for these serious offenses, that he be given a bond at all. And I am going to find, based on the criterion 17.15, that it is not in the best interest, that even though this is a deferred probation in each of these cases, because there's 3, because there's 2 aggravated, that it is not in the best interest of anyone that he be granted a bond in any of these cases. There will be no bond in all 3 cases.
Yes, Your Honor, I would just urge you to conform.
And boom, she shuts it down. No bond, no freedom. That means he stays behind bars until sentencing. After years of wasted chances and broken promises, she's made it clear, protecting the community matters more than his excuses.
With the motion that I filed for a speedy revocation hearing, since the court's denied bond, we have a hearing.
We just had yeah, I mean, he just pled true, and so we'll get the updated report and get it set immediately after that.
I think Article 42A embodies an idea that there'll be a dispositive hearing within 20 days if the bond's reduced. That's my reading of it. So we begin to get an expedited DSI if there's denial of bond. That article, it's in the motion, the 20-day requirement if a bond's denied.
All right, let's get okay. All right, we'll get it set
It's just
in 3 weeks. We'll set it for 3 weeks. Go back with the bailiff.